Good morning. Once again, let's start the session. Welcome to our first panel discussion session on the EU Data Act and cybersecurity, and the main question about who owns the data. We are here to dive into the one important topic of the area of digital transformation, actually, and data governance. If you would ask the EU Commissioner, a hacker, a user, or even a device on the network, who owns the data, everybody would have a different opinion. Yeah? But probably the one who physically has the data would be deciding about who has the right. Yeah? The EU Data Act is a legislative tool aiming to foster a fair data economy in the world by ensuring that data is accessible, is shared across owners, controllers, processors, and users of the data. The key aspects of the EU Data Act includes data sharing, user empowerment, interoperability, fairness, and transparency. The Act mandates that data generated by users and devices should be accessible for both for public and for private entities, promoting innovation and competition. It emphasizes the rights of the user to access and to port their data to maybe different service providers. It encourages the development of standards and protocols to facilitate seamless data exchange between the systems, such that data can flow between the systems, and it encourages the development of standards and protocols to facilitate simple data exchange. If exploring the interconnection between the EU Data Act and cybersecurity and data protection, the EU Data Act seems to create a secure, trustworthy environment for data sharing. It complements the General Data Protection Regulation, the GDPR, by ensuring that data sharing practices adhere to the principles of data protection and privacy. Therefore, it enforces the need for a lawful processing of personal data. And it promotes the adoption of risk management frameworks to identify and mitigate cyber risks associated with data sharing. This is crucial for maintaining integrity and confidentiality of the data. But let me introduce myself and the panelists first. So my name is Roman Krepki. I'm a professional in information security, in data protection, in business continuity management, and in risk management. Actually, with a background in advising organizations on the one side, for implementing robust security frameworks and auditing experience on the other side. I'm ensuring the compliance with information security and data protection standards as simultaneously. Contributing to the development of strategies that help organizations manage risks associated with digital assets, sensitive data, special emphasis on regulatory landscape shaped inter alia by the EU Data Act. But right now, actually, I'm the least important person of this session. And the PCB probably, when setting up this session, was looking for where did this Data Act coming from. And they found it comes from Brussels. Of course, it's a EU law. That's why they collected all the Belgian guys here, all the Belgian experts, because they probably know about that new Data Act as much as possible. So let me introduce the participants. On the first hand, I have Jetro. Yeah, we see. I have Jetro WILS. Jetro works with European organizations as a fractional CISO, helping them turning fragmented cybersecurity efforts into well-governed cyber resilience. He focuses on governance, risk management, and compliance with NIS2, with DORA, and ISO 27001. Jetro holds a master's degree in IT risk and cybersecurity management, where his thesis explores de-risking artificial intelligence adoption through stronger AI security using privacy-enhancing technology. As a PCB certified CISO and ISO 27001 lead implementer and PCB certified trainer, he was training enterprise architects, project managers, service managers, team leaders, and engineers. And beyond consulting and training, Jetro serves as a technical reviewer for packet publishing on several books covering cloud technology, artificial intelligence, and security topics. Jetro, would you please make or share some topics of your expertise with relation to the EU Data Act?
Well, thank you for that introduction. So, first of all, in the first 10 years of my career, I was involved in software development. Either as a developer I started, and then I grew to business analyst, and then team leader in international software companies. And seeing there what happened with all the data that we collected from our customers and how we used it for ourselves to benefit other customers, but never giving that data back to our customers in that sense. So the Data Act has a serious impact in that way of working. And secondly, in the last 10 years, I'm more focused on security in cloud or in general. And I'm a CISO at a branch of the Belgian government. And there we do something similar. We collect a lot of data from our citizens and or municipalities, and there is no formal contract in sharing that data back. So the Data Act will also impact that. We'll talk about that more later in the session.
Thank you very much. Brilliant insight into the topic, but we are still in the introduction topic. My second panelist is Punit Bhatia. Punit is recognized privacy sourcing and AI strategist with deep expertise in the EU data regulations like GDPR, AI Act, and the evolving EU Data Act. With over 2 decades of expertise advising chief officers and data protection experts worldwide, Punit helps organizations to navigate the complex landscape of data governance and AI ethics. He's the founder and CEO of Fit for Privacy and Grow Skills Store. He leads initiatives that empower companies to build trust through responsible data practices. He's a certified fellow in information privacy, ISO 27701, lead implementer, holds multiple further credentials. Punit has authored several books about AI and privacy. His work frequently addresses the intersection of AI, data privacy, and sourcing, offering actionable insight into the EU Data Act implications for data sharing, accountability, and ethical AI deployment. He serves on the board of ISACA Belgium, the Global AI Associations, and the DPO circles. Would you please share some more insight of your bio, of your interesting bio, Punit?
Still want me to say more? You said it all, but thank you so much. Happy to be here. And I think if I have to follow Jetro's model, first 10 years, I was in IT, doing development, business analyst, project management. And I saw that there was a lot of intersection with data or third parties, that's vendor management. So I switched to procurement or vendor management. And then I saw we are still talking about data. Then I went into the GDPR, the privacy, and this Data Act. And what I realized is we can have the GDPR 7, 8, 9 years, whichever way you want to see. We have now the Data Act, we have the NIS2, and we're still talking who owns the data. So I don't know. And then we say there's too much legislation. So I don't know, is it a legislative problem or is it an ownership problem? Or maybe in the modern world, data cannot be owned. It's only about data and its permissions, but we'll talk about that later.
Let's see if we can answer this question by end of the panel. Who owns the data?
Okay, let's go for it.
And my third panelist today is Stefan Mathuvis, with as well as over 2 decades of experience in management systems, consulting, and auditing. Stefan is a trusted advisor to organizations navigating complex regulatory and compliance landscapes. He also works as a senior lead auditor for DQS in Belgium, for which he performs audit in quality management, in information security management, and data protection management systems, and also other related standards. He was listing this before, but I don't want to list them all. There are pretty many. Since 2000, he has guided companies across Europe in implementing and maintaining quality management system and information security management system. Currently, he serves as data protection officer for several organizations. I think you named 6 organizations in parallel. Yeah? In Belgium, in Ireland, and in the Netherlands. And Stefan works. Stefan's work sits at the intersection of information security, data protection, data privacy, and emerging regulations. He has been closely following the evolution of the EU data governance frameworks, including the NIS2 directive, the AI Act, and the upcoming EU Data Act. Stefan, could you please share some aspects on your audience, why your audience should ask exactly you about the EU Data Act?
Because I consider myself as a translator. I like to translate legislation into day-to-day practices. And I think that's my customers are mainly SMEs, so I'm less in the corporate structure, especially as a consultant. As an auditor, I do both. And a lot of my clients see this new legislation, they don't know what to do. I try to translate it, bring it into their frameworks, and make sure that also a smaller organization can comply with the ever more complex legislation. So I think that's why they reach out to me, or to us in the team, to put all of this legislation really into their day-to-day business. That's my specialty. That's our specialty as a team, to really focus on that. And I must say, the last years, it's GDPR, it's NIS2, it's EU Data Act, it's coming at a rapid pace. They're kind of losing track. And also here, who owns the data is a very interesting topic. So I'm curious to see what, at the end of this session, what everybody will think about it. Voila.
Thank you very much, guys, for the introduction. That's an interesting topic about translating, because laws are written by lawyers, and managers of the companies are not lawyers, and they probably don't have the experience to read the law as a lawyer would do that. So you need a translator probably. That's a very important topic. So, but let's start with the main and core part of our discussion panel. Who truly owns the data? Punit, definitely the definition of the data ownership. How is that defined, or how is that mentioned in the EU Data Act? So according to the Data Act, who is considered to be the data owner? Is it the generator of the data? Is it the user of the data? Is that someone who operates the IT system? Or yeah, who could be that?
As you said, we will try to find that conclusion by end of this session, but I'll give you my perspective.
Let's start searching for that.
Yeah, let's start searching for that. So there's the Data Act, but let's look at the data first. So data has many dimensions. One is your personal data. There we don't need to go further than the GDPR, and you as an individual own data. So that's clear. But then all the non-personal data, that's where the debate is. And then in the non-personal data somehow, somewhere relating to us as individuals, and data being generated by machines. Now, as I understand EU Data Act, I understand that it says it's not about definition of ownership of data, it's about who holds the data and who has the rights over that data. So it shifts the dimension from ownership to holding and rights. So the holder is the machine, the party which has generated the data, and then you have certain access, certain rights. So individuals have rights over data. Individuals can access data. Companies can use that data. So it's about fair use, fair access, and rights. That's what it talks about. So it moves you away from the standard or the binary definition of I own data, you own data, or who owns data. That's how I understand. It talks about holding data rather than owning data. It talks about access, fair use. That's where it is. I think you're tempted to ask me something.
Did you study jurisprudence? Are you a lawyer? Because you did not answer the question, but we have the feeling that the question is answered, but you did not answer.
No? Okay, let's try again. So let's first clarify that I'm not a lawyer. Just like Stefan said, he's a translator. I translate and I simplify, so I put it in simple terms because I don't want to mislead people by saying you own the data, because you don't in the modern world. So when you're using Alexa, she, or if it's she, you classify Alexa as she. So she has your voice. She has your voice data. Now you no longer own it. Alexa is the holder of the data. Now the question is, as the holder of data, but Alexa is created by Amazon. So Amazon is the holder of your data. Now the question is, who has the rights over that data? Because yes, your voice, you may think you own, but now with Alexa, so Alexa is the holder or Amazon is the holder. What happens? You have the rights based on the GDPR. Voice is your personal data, so you own it technically, but holding rights are with that. And we will complicate when we talk about data transfers. That story more. But for the defense of my legal colleagues, their job is to make sure that all angles are covered. And when you cover all angles, like you said, you don't have a clear answer. Everybody thinks it's answered. But here, the short answer to the EU Data Act is, it's not about holding of data. It's not about ownership of data. It's about holding of data and who has the rights to do something. And when you talk about rights to do something, we talk of concepts like permission. If you have permission to do things. So when I have spoken to Alexa, Alexa has my voice. Do I give it the permission to analyze my data? That's where there are consent mechanisms. Then in Alexa, do I give it the permission to use the data? Yes, to give me the answer to my question. But do I give that permission to use that to train their AI model? I don't know. Because two things. What are Amazon's fair use practices? Debatable. So, and then second, what are the permissions that they are asking me? Some companies, they are transparently asking me, okay, can I use your voice to train my AI? That's okay. Can I use your voice to share it with third parties? I don't know. So it's about access and fair use.
Exactly, very good question. Rights and obligation, or very good jump to another to our second question. Rights and obligations. What, Jetro? What rights and obligations arise from different stakeholders, companies, individuals, public bodies, regarding that data?
Yeah, that's a great question. And if you can go to the next slide, this is an overview of the Data Act in 3 points. Because I like to start always from a helicopter view, like what was the problem again? Why is Europe doing this? And then we can dive into the details. Now, the next two or few slides are from Johannes Vrana from Germany. He has a great YouTube video, which all the credits go to him. But here are the 3 key points of the Data Act. Why is Europe regulating again something new? And there are 3 objectives. First of all, we want to have access and use of the data that we give to the producers. And I'll talk more about that. And the John Deere example is a great one, as I'll explain in a moment. Second, Europe wants to have fair rules for data usage, that you can actually extract your own data and share it with another party. And that is fair to use and not hoarded by these monopolists. And third, and this is very interesting if you're in cloud, especially as a CISO, the cloud or the Data Act says we want to have portability, that you can move from one cloud service provider to another, which is very interesting. I will talk more about that later. Now, if you go to the next slide about your question about the ownership or the rights and obligations, I really like this example. So if you remember John Deere, the great agriculture producer in the US, they have tractors and these things. And imagine you're a farmer and you buy a tractor. But now over the years, these have become connected and they're smart devices now on wheels. And you're using it to farm your crops and all these things. And the thing collects all the data. And it goes to John Deere. And John Deere now owns the data and then uses that data to sell you other services. Like we can help you improve the crop revenue, let's say, because we now know the soil samples and everything. So basically you're buying a product, you're using it, thereby it collects data, it goes to the producer, and then it sells you a license to use your own data for insights. And then John Deere hoards everything and they don't share it. So Europe says, that's by the way on the left side of the slide, you can see there, you're the user and everything goes to the manufacturer. And now we have the EU Data Act, which brings us to the right side of that slide, and it says now we're going to have 2 markets. We have the market for connected products, so I'm buying the machine or the device. And then there's going to be a second market for the data-driven services. Let me give you an example. If you drive an EV, it's basically a computer on wheels, and it's collecting all the data, telemetry, and it goes to the manufacturer. And they will use it to optimize the driving experience, all nice. Now, a few years ago, somebody came to me and said, Jetro, do you know what happens with the tire pressure of your car, your EV? I said, yeah, it goes to, I'm driving a Volvo, so it goes to Volvo, I assume. They said, yes, but you know what they do with all the tire, the pressure of your tires? I said, no. They map the road quality. Because every time you go to the bump, the pressure changes, and now Volvo and other manufacturers have exact good maps on which road quality needs more attention. You know what they do with it? They sell it to governments. They can say to the government, we know exactly which road segments you need to treat first. So just telemetry from my car and your car is being used by these monopolists or manufacturers to then sell and gain revenue. But here's the trick. If you say, I want to start a startup and I want to use that data to bring innovation, you cannot have it because Volvo and BMW says it's ours. The Data Act changes that. And the Data Act opens up a new market that says, as a third-party service provider, you can have access to that data. That is the Data Act. That is the fair and accessible use. So to answer your question concretely, the rights and obligations as a stakeholder in the sense of the manufacturer, now you have to separate the product you're selling from the data and open the data to third parties.
Thank you. But maybe the air pressure of the tires is not so sensitive data. There might be other examples where you have more sensitive data in the hospitals or maybe in other, I don't have an example in other customers, in order to protect those data from against cyber attacks. What measures are necessary to safeguard, to protect the data, Stefan?
Well, I think to know what measures you have to take, it's important that you know what you have to protect. So for me, the first thing you really have to do is data classification. To identify which sorts of data do we have, personal data, non-personal data, financial data, IP for your company. So that's one difficult thing. Even in 27001, we see that as a very difficult step for companies to take to identify the data. Once you've identified it, then you come to the second point, is who can access it. And there, least privilege principle is important, role-based access. So once you have done that, then you can think about your technical safeguards. End-to-end encryption, MFA, zero trust architecture, securing your APIs, a lot of things that you can do. Data pseudonymization, anonymization can be also included, which can be an interesting topic later in a format like this, where data silos will being sold, and maybe you can put data back together and maybe make non-personal data personal data again. So that's going to be a challenge. Then, of course, the real goal of the Data EU Act is to share all of this data. So, okay, there we need some secure data platforms. How are we going to share this data? It's like with the cars. I also drive an EV. All of this data is going from my car to somewhere. Is that track secure? Is it not secure? So interesting to see what will happen there. We have to monitor what we do with all of this data. What are we collecting? What are we giving away? And during my 20 years career, I'm sometimes so surprised that companies have no idea where their data is actually gone to over time. People go away, they made contracts, they made API connections with third parties, and sometimes there's no governance on it anymore. So that's a challenge. Of course, the people in your company, they have to understand all of this. You have to translate this legislation into day-to-day practices through training and awareness sessions, through accountability of your management. So that's also an interesting safeguard that you have to implement. And then, last but not least, is those third parties. You're going to give data to a third party. You might use technology from a third party. Think of chatbots, for example. So that's also something where you have to contractually make sure that you put enough safeguards into your contracts. So it's not one thing that you can do to secure that data, but you have to do a lot of things to bring it all together.
Stefan, but in if nobody is enforcing the companies to implement those measures, all those measures are costing money. Are there, Punit, maybe you know, are there any regulations, other regulations that enforce the companies to implement that, and how Data Act interacts with maybe GDPR if it's personal data, or NIS2 directive, or DORA?
It complements and of course interacts. So GDPR, if you have to talk about personal data sharing, managing rights, access, focus on GDPR. But all the non-personal data, like Jetro talked about Volvo collecting the tire pressure. We also talk about medical devices, because these medical devices which were scanning or doing an ultrasound earlier, that was on the device, never traveled, and nowadays it travels to US immediately. So I was talking about Alexa. So all that data, or even now, I don't know if that camera is recording and streaming to YouTube. So all the data at every moment is traveling. And for that, we have the Data Act. So Data Act streamlines, like if I extend the example of EV, few years back when I got the EV, I thought I have an app from Mercedes. So it was fun. Few weeks later, my friend tells me, there's another app which tells you analytics about that data, and it can integrate or connect with Mercedes. I was very happy because it could tell me, and it gamifies me, saying you are driving like this, you should drive like that, you'll get more points. So it's changing my behavior. But behind it, what's happening? Data from Mercedes, my car is going to Mercedes, and some Mercedes giving access to somebody. And then few months later, I have the EV charge card. That also has a data. So what's happening? It's that Data Act which streamlines, facilitates how this data is accessed, how this data is shared, and who has the rights. Now, if it's personal data, the GDPR, but for the rest of it, how do you do it? What are the protocols? Even the GDPR talked about the data portability as a right. So all those things are enabled through the Data Act. But you also talked about NIS2, right? Yeah. So now all this data needs to be secure. It's okay. It all feels good that my data from my car is traveling all over the world, and I can get nice analytics. I can be rewarded for behavior, and I can modify my behavior. But what if it goes wrong? What if somebody changes that data, changes the speed of my car? And it also happened one time, the car thought I have an accident. I was just driving on the road. But then I realized there was big air which was on the road, and the car pulled me on the side out of 3 lanes automatically. And then somebody calls me and tells me that, hey, you have an accident. I said, no, I don't. So now in there we need security. I could have had an accident because the car stops right in the middle of the road on a highway. So all those things need to be secured, and that's where we have NIS2, we have other regulations which are saying how do you protect this data. Now we're talking two different things. We're talking data sharing so that the data can be leveraged, because data is the new gold. But we're also talking about permissions. What can you do with the data? Because you cannot do anything and everything with the data. And then the third thing behind it is, when you have the data, you have responsibilities. But the company that's sharing the data, so in our case, the Volvo, the Mercedes, the medical device company, or whosoever, they have the obligation to make sure while data can be accessed, data can be exchanged, data can be utilized, and data can be converted into many other useful information, like what's happening on which road. The source of the data, or where the data is being generated, held up, I use the term data holder, remains protected. And for that protection, we have the NIS2, we have the other legislations. So those still determine, and they don't act in isolation. So GDPR also talks about protecting data, but it stops there and says you should notify within 72 hours. Then we have NIS2 and with the Data Act. So all these interact seamlessly with each other while in their defined scope. So Data Act purely from the dimension of how do you exchange and share data, and who holds the data, who has the rights. GDPR from the personal data rights, personal data protection, and personal data security. NIS2 purely from a security, because you don't want the GDPR to talk about security and NIS2 to talk about personal data, or Data Act to talk about something else. So all of them act in harmony, but there are common elements. GDPR talks about portability, Data Act talks about portability, and then NIS2 talks about when you are exchanging data, transferring data, there is security on top. So it's all interrelated, but in defined domains.
And you made an interesting point that this camera is recording and putting the live stream into YouTube. Just I imagine the world where the data is flowing seamlessly between the systems, between the platforms. And I thought it is required to establish a proper user access rights for this data. Stefan, what technical obstacles exist when implementing data access rights to the data which is not residing in a system but flowing between the systems?
Yeah, I think that's a nice word, this portability, but I have never seen it in practice. It's going to be challenging to get that in practice because you have interoperability, technical complexity. People develop things from out of their own technology, not out of a regulation. So that's going to make it different. As data stored, different formats, different systems. How can we do that? You need standardization for that. So that's going to be something to look at. Will there become more global standards? But then you have to think about, of course, we're the only continent bringing in all of this legislation. The US, China, Russia, they don't care. So, and most of the big hyperscalers are not here. None of them are here. So it's going to be interesting to see how willing will these companies be to comply to this legislation or to this principle. Then, of course, we have data protection. There I have a little bit more faith because I think the EU there was an example that was picked up in other countries and other parts of the world as well. So there we might still have a chance of giving us data subjects the rights that we deserve. But of course, IP is an interesting one. Everybody wants to keep their own IP. If you have to start sharing things, you're going to share some parts of that IP. And then it's interesting to see how far companies want to go in this and what the business model behind will be. Who's going to pay for all of this data portability? Is it going to be the user? Somebody has to pay at the end because technologies need to change.
It's always the customer.
It's always the customer. And then, of course, liability. I gave you something. What did you do with it? Did you misuse it for something? That's also an interesting topic. And I think there, can you keep control of this supply chain? Where is it going? If you look in some legislations like DORA for the financial world, that they have a very strict element in third parties. So there you stay accountable for going all the way down into this legislation. But in practice, that's very, very, very difficult. Okay, you can make nice contracts, but is that enough? Is that enough to safeguard it at the end? So I think there will also always be cost restraints, resources restraints. So it's going to be, personally, I don't believe in portability. I think it's too late. And I don't think I'm going to see it in my lifetime that everything is going to be portable from one system into another.
Jetro, but how can different systems and platforms communicate to ensure that the data is communicated in a secure manner and the data transmission is still efficient?
Yeah, great question. So, as a developer in my early career, I've seen many things happening. I give you the example of what happened in Belgium. There was in 2015-16 an app called Cake. And the idea behind it was it would connect to your financial transactions, so your home banking app. And then it would give you analysis and insights on how to optimize your household money. That was 2015, really nice. And I joined that program, let's say. But here's the thing. The banks wouldn't share my own financial transactions of my own bank account. It was a very difficult process to connect that app to the financial ecosystem. Now then PSD2 came out of Europe, the Payment Services Directive 2, which basically enforced banks, you do not own the financial transaction data, it's the consumers, it's the the customer. And then they opened it up. Now, what PSD2 did for the financial sector, the Data Act now opens for the entire ecosystem. Okay, but it's only for connected devices, right? So it has to be an IoT device is connected, right? So that is one thing. So I see the interoperability in the sense that you need to have a standardized API, and you need to have a file system or a structure that is documented. If you remember, Microsoft had something similar way in the 2000s with the Word file. It was doc in the beginning, which was proprietary, and then they moved it to docx, which is open and open source basically. Everybody can use it. That's the same thing. So if you're building a product that has connectivity and it's collecting data, you need to make sure that there is an API behind it that others can consume. Okay, that's one thing. Now, because the whole thing about the Data Act is you want to prevent data monopoly. Europe says there cannot be a lock-in. Now, you mentioned an interesting point about intellectual property. Please note that the Data Act only talks about the raw data. The way you analyze the data, the model that you're training with AI, that is proprietary. That is your value-added thing. But the data, the crude data, is available. So that's the whole thing there. So to answer your question more directly, have a data standard, API, and have it well, like data schemas and ontologies explaining the fields, you know. In the old days you had XML, if you remember still that. Now it's JSON, where you have to explain the schema. You have to do that as well. Now in the next slide, which is the last one I'll show, is actually there are two ways that the EU Act or the Data Act says how to do this. Either you have direct access. So let's say you're the John Deere consumer and you want to access that data, you can do it directly through a portal. Let's say John Deere has this portal that you can get that data. Ideally, it's with an API that streams, so live streaming. So while you're using the product, the hardware product, within a few minutes you have it, the data collecting. Right? If that's not possible, then Article 4 of the Data Act says it needs to be indirect access. Meaning you as a user, you can reach out to the manufacturer and say, I want my data. And then you can have that data set with the ontology, so with the explanation of how it's structured. And then you are free to give that to any data-driven service that you provide, that you choose. Right? Think of it like with GDPR. There you have the ability, I want my data. Give me a full data of my personal data export. Right? Now it's the same thing, but with your entire data, so that you can use it for a third party that will help you with the new insights and all these things. That's the next step.
Stefan, thank you very much. Stefan opened a question about liability. So who is actually accountable for things that can go wrong? Punit, who is liable in the event of data breach of a cyber attack? Is it the owner? Is it the processor? Is it even the user? Who is actually made liable if an electric or if a self-driving car is making an incident?
If it's personal data, then it's clear. There are two entities. There's a controller who decides on the purpose and collection of data. They are the responsible, they are the liable party. And then there is processor who's processing the data on your behalf or on behalf of the controller. They are liable if negligent or as per the contract. So there it's clear. Now here, there can be lots of opinions. Because as Jetro and Stefan are saying, the raw data in itself doesn't have any value. So if it's breached, who's liable? Nothing, because the data in itself didn't have value. But somebody who created value out of that data, if that data is breached, then it's the holder who is. And now the question is, which holder? The one...
Exactly. I want to ask, which holder? Either the owner of the data? Is it the processor of the data?
So the one who was in holding or possession of the data at the time the breach.
Please speak a bit louder.
Is that?
Yeah.
Is it better now?
Yeah.
Not yet?
Perhaps the
Just a little bit more.
volume of the...
Okay, interesting, because I'm hearing my echo now.
No, it's
I'm asked for data about...
No, it's on. It's on, it's okay.
So I'm now asked, okay, maybe it was not on, so no worries. Anyhow, we've had half the conversation already. So what was the question? We were talking about the liability.
Who is liable in case of a data breach?
Yeah, so we were talking about who is liable when this raw data is transformed into some useful insight. The idea is the party which has had a breach, which had the challenge with its systems and its systems are breached, that has the liability, or if that's the company that's creating wrongful insights, they have the liability. So you cannot, the liability moves as the data moves, but in terms of responsibility is with the holder.
Thank you very much. And now I want to go a little bit more into the practical implementation, where the theory meets the practice. How businesses do have to implement the EU Data Act? How can the organization business effectively meet the requirements of the Data Act? Jetro.
So if you are this manufacturer and you're building your digital product on top of a hardware product, or you're the IoT collector, or you're in the port, let's say the port of Antwerp, where you're collecting all this telemetry, right? And now you have to adopt the Data Act. There are a couple of things, and it ties into what Stefan already mentioned a bit, like mapping and classifying your data ecosystem. You cannot, well, as a CISO, you say, we cannot protect what we don't know, what we don't see. You cannot share what you don't know you have, right? So first you need visibility. That's the foundation of compliance. Like, what type of data are we collecting? How are we using it? Where is it stored? And then also with data classification. Is it personal data? Is it confidential data? Is it semi-public data? So I think the folks in the data governance team are going to be very happy with this act, because they get more work, and there's a new driving business, a taxonomy. That's good, that's the first step. Then you need to have accessibility. Now that you know what type of data we're collecting from our consumers or customers, how will we give them access, or other partners access? So then talk about the APIs, the portals, and everything there. Right? APIs and exports, you're just a data export, that's the worst case, but it's better than nothing. And then, as a CISO, I would say you need to implement security controls. Because you don't want, by accident, personal data getting leaked. You don't want, by accident, confidential data, that is intellectual property, getting leaked. So that would be the third step. So map your ecosystem, build your accessibility using portals and APIs, and then have your security controls implemented.
It's very, very good approach. What I often say to my customers, before you can protect some data, you need first to inventorize. You need first to know what you have, and then you need to classify whether it requires protection or not. No? And then after, you implement the measures, the controls for that. But a very important point is training and awareness. Yeah? And what steps are necessary to raise employee awareness for the new rules arising in the EU Data Act, in addition to what we already have in cybersecurity, in information security, in data protection, and in safety, and whatever all the rules? Are there any new rules in AI Data Act?
Yeah, I think interconnecting with what Jetro just said, there's a lot of things to think about. And you have a lot of players in your company. You have a lot of different functions, different roles. You cannot make a one-size-fits-all training and awareness program. So it's important that you identify the different roles that you have and the part that that role plays in the overall picture. So there, we already know privacy by design. We know security by design. Maybe now we have to have portability by design. So your developers, they need to understand what this portability means, that they have to have a separation between raw data and the IP they built, so that it's portable. So that means you need training on your developers on a specific topic. On the other hand, you need to make contracts. So your legal department also needs to be trained on the consequences of not complying to the EU Act, while you have your regular users or other functions in the company that have other needs in this whole flow of data. So I'm a strong believer of role-based training content. also with micro learnings. Exchange of experience. We as auditors, every year we have an exchange of experience. It's mandatory for each standard that you do. And we pick up a lot from each other there because we're all out in the field seeing things. So bring practice into your training programs to make sure that everybody in your organization understands their role in the data flow and in the EU Data Act. Do you have to train them on the articles of the EU Data Act? No, not at all. That will not help. But train them on what their role will be in these articles. So translate it into role-based learnings. That's going to have the biggest effect on the whole.
Let me throw in a short commercial into this. BCB Skills is doing micro-learning pretty perfectly. Finally, we see now that legal, technical, and social aspects are in focus of the EU Data Act, and interdisciplinary approach or exchange is therefore essential and to optimally address the challenges and opportunities regarding the data ownership question, regarding cybersecurity, regarding data protection and innovation. Yeah. So now, looking to the time, let me open this panel session to the questions from other participants. Do you have any more questions to the guys talking about Data Act?
I just want to thank you for your insights. I think it was a good learning experience there. I just want to understand some practical advice also, wherein you see a lot of organizations deploying AI through Copilot or equivalent, and to promote more internal use of their own data. We advocate data classification, but you see it as an after act. So how do you see evolution of governance versus people going in for, say, purview for data classification and data leak prevention, and then over that another layer of tooling and another layer of platforms, and then trying to combine everything? So where do you see governance move with legal contracts also? Like, how do you see that work?
Yeah, for me, implementing 27001, this is a very common topic. The problem there is that when we come in, the damage is already done. Because everybody is curious about new technologies. Hey, ChatGPT, let's start using it. So I see CFOs putting their strategic business plan into a non-licensed ChatGPT session. Boof, everything goes in there. Then I come in and say, oh guys, you should have thought about this before. And we're always a step behind, at least with my clients. So the challenge is here, think ahead. You have to have a risk-based approach in your organization. And you need to think ahead, but you need to think fast because technology is fast. Today, somebody showed me, I knew Revolut as a banking app. Now there's another one, WISE. I've never heard of it. It seems to be very interesting. And younger people already tried it out. And that's a challenge. What I see is you have to be fast. When you read something about new technology, somebody in your company needs to think about it. Hey, can this affect us? And we need to make some rules on it.
Yeah, and to add to the governance question, as a CISO, I would stress the importance of the secure software development policy. If your company is developing software for the B2B market or B2C market, put in that policy exactly what you need, like DevSecOps and secure testing and all of these things. But now add a clause or a paragraph on, for certain data, we need to have accessibility from third parties. Right? Have it built into your policy as a mindset.
And I would add the risk management aspect. Start with what's the risk and then manage it. And especially with these technologies, you learn the risk as you start using them. So that's the challenge, but try to be proactive.
Thank you. My name is Jetro from Uganda. One is perspective from me, governance related, that in my experience I've found that as technical people or people who auditors, that we are left at a level of only operational. And at strategic level, we find that at the board level, we don't have people who are thinking like us. So I think it's also a call for all of us who are like-minded to aspire to be at the board strategy level rather than operational, because then we shall always be playing catch-up. Now, my other concern is that PCB is a global standard, and I would have appreciated if we had also maybe a judge, a lawyer on the panel, because some of these laws are about perspective. When you look at the EU Act, yes, it is a global, something that we look at, but then we also have local laws that also impede data governance. Say, for instance, a couple of months ago, in Uganda, we had the court ruling that Google had to pay a fine because they were collecting personal data and yet they were not registered as a local entity. So while we are looking at the global, GDPR, there are also local laws. So as we are training, we need to see how do we intersect the two? Because yes, you have perspective globally, but locally there are also laws, and yes, they may be moving slower, but they are also affecting the way we look at this data, especially in transit, because now data is a new gold, and it's no longer resident in only one jurisdiction. So that is something that is always going to be playing into the hands of this whole perspective of it. Thank you.
So I'll take that. I think your first question, not enough regulatory or legal people on the board, or questions like why are technical people not on the board. I think it goes very basic fundamental question. Business is driven by business objectives and its responsibility towards shareholders. And shareholders ask for growth. And hence, if you're business minded, you are usually on the board. We tend to think, all of us here, that regulation or control or security or privacy or audit or data act is the most important thing. That's for us, but for them, it's not the case. So if we start thinking business, we expect them to think of us, but it's other way around. They will not think about us. We will need to think about them. If we start thinking business, if we start being business friendly, and we say how this act can help them leverage the power of data and bring more business value, I think they would like to listen to us. So that's the answer. And it's the same with GDPR, it's the same with NIS2. So if we say, here is a compliance burden, comply with GDPR, spend 5 million, and we will restrict your data transfer, and we will restrict this and this. Difficult, very difficult to be heard. Of course, you could get heard in 2017 by saying 4% of fines, but it doesn't bite anymore, especially after GDPR, because now with the EU AI Act, 6% doesn't bite because nothing like that happened for them. So think business, that's the answer. But the second part of the question, if I understood, is multiple legislations, multiple laws, how do you see, because the data is traveling, navigating and flying across the board? The simple answer is go for the, normally we say least common denominator, but here not the least common denominator, the highest common factor. So if you're thinking of privacy, for example, the highest common factor still remains GDPR after 7 years. Comply with that, build in an approach, and typically for most legislation you'll be good, and you have to do a light analysis or an audit. Same way for this act, I think there are not enough standards which are promoting, saying how do you exchange and transfer data and who has the rights and ownership. Then use it, or maybe use NIS2, or maybe use whatever is available. So use the greatest common, not the least common factor, highest denominator, and comply with that. That makes life easier. Now, of course, you lose a few things by complying with the strictest, but you also gain in the long term, especially if you're a global company. You have to see like Microsoft or a few other companies, they are saying we are compliant with these legislations, and we are applying even in the US, even in China, where those legislations are not there. So that's the only way.
Thank you. There is one more question.
I think I have the micro. I'm thinking more practicality. I'm a small company in Germany. If I have to prove compliance with GDPR, with a EU Data Act, with EU AI Act, so I'm dealing whole year only for compliance. So what's the overlap, and how can I get easily prove my compliance with all these regulations?
Management system?
Yes, management system is the answer. It's because once you implement the management system, there will be, and you certify it, there will be a third party looking at that management system and making sure every year that you still comply with the framework that you've set up. Is it 100% waterproof? No. But at least it controls your methodology and it controls the output of that methodology. So in the NIS2 regulation, there you have the choice. In Belgium, you have the choice of two frameworks. Either you choose 27001 or you choose Cyber Fundamentals, which was created by the Cybersecurity Center in Belgium. So you can go two tracks. And the companies that go under 27001 or under Cyber Fundamentals, they are considered to be compliant to the legislation. But it's always hard. But I think setting up a framework and certifying to a standard that is related to the legislation is the easiest way to go.
Okay, lots of work.
Thank you very much for your very inspirational participation during the panel. But I have a concern. Now, I noticed talking to a few clients, there are some companies with a full operational board here. So let me say gathering data, operationalizing the data. However, I'll just take a simple example. I have a whole operational team in Africa who will have to access this data, do some work, maybe not save the full data, but sometimes partial. How does the EU Data Act come into play in this situation?
Yeah, so if the data remains within your company, but it's just across continents, the Data Act is geared towards sharing the data. So it's for outside of the company. So I would say the Data Act is not that much of a concern as long as you're having the portal and the accessibility for third parties. I think more if the GDPR comes into concern, if it's going across Europe, beyond Europe with personal data, more the GDPR thing.
Thank you. Guys, sorry for, I'm looking at the time and we have to wrap up, and I would be very lucky if we speak in the panel. Let me just summarize and wrap up our panel. Jetro, how would you summarize the discussion panel in just one sentence?
In just one sentence, okay, done. No, it's
challenging.
Europe's way of unlocking the data. You want access, fair use, and portability. That's it.
Impressive. And Punit, from your perspective, what is the most important key takeaway from our panel discussion now?
I think look at EU Data Act, not the AI Act, Data Act as an enabler for exchange of data. Don't look at it as a regulation that restricts you. Rather, it opens things on how to exchange data.
That was more than one sentence, but
you didn't ask me for one sentence, so I took the liberty.
And Jetro, finally, sorry, Stefan, finally, what is your conclusion on our initial main question of the panel discussion panel? Who actually owns the data and why?
Well, my conclusion is...
Not one sentence.
It's one sentence. The conclusion is the future of data governance isn't about ownership. It's about responsibility, transparency, and trust between all parties.
Thank you very much. Thank you very much, participants, and thank you very much to the panelists, and thank you very much for your audience. We all hope to speak to you during the break session, and thanks for attending.
Thank you.